Hey, here we go. Good afternoon, everyone, and thank you all for joining us for today's a month of service presentation of Evictions. Know Your Rights. My name is Nia Murray. I am the programs coordinator with Neighborhood Recovery Community Development Corporation, and we are one of the partners in the A Month of Service collaboration. Also included, we have the City of Houston's Department of Neighborhoods, and on behalf of our presenting partner with Lone Star Legal Aid, we have Mr. Benjamin Daly, who will be presenting the information for you all today. But also included in the partnership, we have the Earl Carl Institute, Texas Legal Services Center, Houston Volunteer Lawyers, Harris Central Appraisal District, and the Harris County Tax Assessor Collector's Office. And together, we all make up a month of service. And basically, what a month of service is the collaboration of all eight of our organizations coming together every single month to offer a variety of different workshops, resources, and information to the community relative to community empowerment, asset protection, asset building, and the maintaining of generational wealth. Several years ago, we decided to collaborate and come together and try to pool all of our efforts to reach a larger audience, to create a greater impact and is get as much information out to the community as we possibly can. So this has been working out as far as the partnership goes. Um, the virtual platform has allowed us the opportunity to reach even more people throughout surrounding counties and across the entire state of Texas. So wherever you're joining us from today, know that the information that does get presented here today is relative to the entire state, and it's not just for the city of Houston or Harris County or things like that. So know that part as well. Unfortunately, we are not back into a full-time virtual, sorry, in-person setting that we did have to transition to the virtual platform due to the pandemic several years ago. And we're trying to kind of slowly get acclimated back to being in person and offer a hybrid where we're doing in person and online at the same time. So look for that to come pretty soon as well. But do know that information that also is presented here, as well as our other workshops, is for educational purposes only. None is to be considered legal advice or to take the place of any kind of legal advice that you receive from an attorney. So we do encourage you to reach out to our legal service partners like Lone Star Legal Aid if you do find yourself in need of any civil legal assistance. And Mr. Daly is going to go over into some more information about the other services that Lone Star Legal Aid also offers as well, if it's not just for evictions. However, this is your opportunity to ask whatever questions it is that you may have. We just ask that you keep your questions to be in general as in nature, as to not divulge any personal details about your own particular situation, because we are recording this session as well as broadcasting live on our social media platforms. So we don't want your personal information kind of getting out there for everybody to have access to. So we do want to try to protect your privacy as much as we possibly can. So do keep that in mind. Feel free to type your question into the chat box or unmute yourself at the end of the presentation, and you can ask your question directly of the presenter. If you are joining us on social media, then please feel free to type your question into the comment section, and I'll make sure that your question is read aloud at the end of the presentation. So with that being said, I want to welcome you all and thank you all for joining us this afternoon. And we do hope that you received the information that you needed when you registered for this particular presentation. So again, if you do have questions, please, this is your opportunity to ask the experts in this field whatever questions that it is that you have. Again, keep them general in nature. But with that being said, Mr. Daly, why don't we go ahead and have you introduce yourself, and then you can go right on into your presentation.
Sounds good. So my name is Benjamin Daly. I'm a staff attorney with Lone Star Legal Aid's Eviction Right to Counsel unit. And this is Eviction Know Your Rights. We're going to go through some basic information about what the eviction process looks like, some common issues that you see, and hopefully provide some information that will be helpful in your future endeavors. Special acknowledgement to Kim DK, my colleague, who authored these slides. So let's get started. So Lone Star Legal Aid is a 501c3 nonprofit law firm. We have a long and storied history. We represent low-income individuals in a variety of legal civil matters, not just evictions. We also have, aside from evictions, some specialized units. So, for instance, a family unit, and we have a public benefits unit and some housing consumer attorneys. We also have some general practice units that serve specific clients in different communities. So, for instance, we have a veterans unit. We can offer anyone anything from simple advice on a legal matter that you're dealing with to full representation. We'll give you more information on how to apply at the end of this, but just know if you're having issues and you need additional assistance, feel free to apply. So the agenda today, we're going to go over a lot of basic stuff. We'll talk about leases, terminating the lease, what to expect for the notice to vacate, what the actual lawsuit looks like. We'll talk briefly on some sort of special cases such as public housing and subsidized housing. We'll talk about some other related legal issues that you might see in an eviction. And finally, because we always get asked about the security deposits. Just a brief disclaimer before we get too far into this. Should know that the laws are always changing. The legislature is currently in session, and there's been a number of proposals that would, have a rather big change to eviction law if they get passed. We don't know what's going to happen. So just be aware. We will keep you up to date on what happens. If it's a few months later and you're wondering if laws changed, make sure you watch the next version of this presentation. So to get into the substance, first thing to note about landlord-tenant law is that almost everything begins with the eviction. I'm sorry, almost everything begins with the lease. Texas allows for both oral and verbal leases. A lease is basically any contract between the landlord and tenant that establishes the rules that allow a tenant to possess the property, occupy the dwelling, use the dwelling in exchange for usually rent. Keep in mind that a lease term for longer than a year must be in writing, and it is a valid contract. And so a lot of tenets of contract law are going to apply. Leases are going to control the vast majority of disputes. If the law says one thing, but the lease provides for something else, it's entirely possible that on that particular issue, the lease and those rules will actually control, not the we call the default rules provided under the law. So that means you might be waiving some rights. It might change some timelines. So just be aware if there's any question about, what your obligations might be or what might be owed to you under the lease, read the lease itself. Tend to have oral leases. Keep in mind that, because it's not written down specifically, you're going to want to take some steps to document what the terms of the agreement actually are. That way, if there's a dispute, then you have something you can refer to. It's very important to read over your lease and know what the terms are. Leases usually provide for most, if not all, of these. So the first thing is monthly rent. Lease should let you know when and where to make payments, how much the payments are. It'll establish whether there are late fees or any other forms of fees. It may also provide information about how payments are going to be applied. A lot of standard leases have, as part of the agreement, a clause that says that the landlord can take your payment and apply to any fee or any charge that's valid under the lease before applying it to rent. And that can have rather significant implications in the eviction context. Most written leases will establish the lease term. Usually this is what we call a term of years, which basically just means it's a set period of time. So most standard leases you're talking about, they will go on for a year. So, if you were to get a lease today, it would end this time next year. Some leases, however, they do allow month-to-month leases. So instead of the lease term being a year, you just have a renewal period of every month. Some leases also allow the lease agreement to be renewed on month-to-month term if the lease expires and there's not a subsequent lease signed. So it basically provides the landlord and tenant the ability to continue on under the same rules, just under a month-to-month lease, not a full lease of years. A lot of leases will include references to committee rules or policies. So they may incorporate sort of any rules of conduct that the landlord might apply to the complex. Almost all leases will have some form of signed addendum. Those could be concessions. Those could be sort of additional information that's not provided in sort of the standard lease, but are applicable to the complex. And then if you're on public housing, that'll include a HUD or housing authority agreement. Many leases will also define what the acts of default are. So usually failure to pay rent, is there any material breaches? Oftentimes the community rules will be incorporated into the lease agreement, and violating those will be defined as an act of default. And that should provide information about what happens in case of early termination of the lease, or what happens if you get to the end of the lease agreement, it's not renewed, and you hold over after. And finally, as you mentioned, the lease can incorporate certain timelines. So, for instance, if you're at the end of your lease term, the lease might require that you provide advance notice of non-renewal. It might provide the landlord a timeline to provide you notice of non-renewal. It might alter the notice to vacate timelines, and it might provide additional information about when a notice of default can be given, especially if you're on housing. So in the eviction context, everything begins with the lease being terminated. This can happen in effectively a couple of different ways. So the first way is the lease just naturally comes to its end and the landlord decides they don't want to renew the lease. In those instances, the landlord will give a notice of lease termination or non-renewal. As we mentioned, the lease will contain language specifying what that timeline looks like. You normally see either 30 days or 60 days. Once the lease is terminated, once that sort of timeline comes to an end, if you stay beyond that, you become a holdover tenant. At that point, you are vulnerable to, we call it holdover eviction. Now, keep in mind that, except in very limited circumstances, you have no ability to make your landlord renew your lease, in the same way the landlord cannot make you renew your lease. So, if you do get a notice of lease termination, it's very likely going to be valid, and it's very likely that you'll have to leave by the end of that term or else face eviction. The other way a lease can be terminated is if it's terminated during the actual initial term of the lease. So if you have a lease for a year and in 6 months you get something happens and one of the parties wants to terminate the lease, that's an early termination. If the tenant is terminating the lease, there are certain instances in which the lease agreement will provide certain penalties for that termination. So just be aware, review your lease if you're thinking about terminating your lease early as a tenant. For landlords, usually there's only a few different ways in which a lease can be terminated for cause, and we'll talk about those. So there are certain instances in which the statutes do provide a right to early termination. We'll go over some of those. Oftentimes, these are rights that are assigned to the tenant. So in other words, under these statutes, the tenant is the one who has the right to exercise the right to an early termination. Normally, the lease requires, the lease may require that you give notice that you're exercising these rights, or review the lease. The statutes themselves are also very specific about what the obligations are of each party. So I'd recommend, if you're thinking about terminating under one of these grounds, review the statute, or better yet, talk to an attorney. The first one is family violence. Certain instances, you can terminate lease early if you're involved in a family violence incident. Certain sex offenses or stalking. In the case of a tenant's death, the state can terminate the lease early to avoid future liability, although past due obligations are still recoverable. Notice is not necessarily required in that instance. And then there's certain instances in which, if you're in the military and you're deployed, you have a right to early termination. As you can see from the slide, some of these are waivable. Some of these rights are not waivable. So again, refer to each of the statutes or contact an attorney for additional assistance. Another thing we see often, I want to spend a little bit more time on this, because we unfortunately do have disasters here in Houston. We do see issues like this often. What happens if the property is affected by a storm and one of the parties wants to terminate the lease. Casualty loss is governed by the property code. If a premise is made totally unusable for residential purposes and the loss is not the result of the tenant's fault or negligence, excuse me, I'm so sorry about that. Either party has the right to terminate the lease. If the premise is made partially unusable, not totally unusable, neither party can terminate the lease, although you can petition for reduction in rent. Now, keep in mind, whether a premise is made totally unusable or partially unusable, that's a fact issue. So that is something that, in order to advise on that, we would have to look specifically at what the damage was, how it affected the property. And I mean, it can go either way. We've seen instances in which a tenant has, hang on. I am so sorry. Let me quickly log out of that.
Okay. And while you're doing that,
Yeah,
just a reminder.
I'm so
That's okay. While he's doing that, again, just kind of want to remind everybody, if you do have questions, please feel free to type it into the chat. In addition to that, this session is being recorded, so we will be sending out a link of the recording for you all to go back, along with any kind of references that he makes mention of. All of those resources and everything will be sent out to you all as well. So do keep that in mind. So if in case you guys know of somebody else that may be facing eviction or whatever, then you can forward the information along to them as well. Okay, you ready?
yeah, I'm so sorry.
Okay.
I thought it was
Things
out of
happen.
that app. We don't want privileged information flowing out there. Not saying that this works.
Things happen. Go ahead.
Yeah. um, so it's another one where you're going to want to review the lease, see if anything's waived, because the allowance that tenant can petition for reduction in rent, that could be waived or altered by the lease. Um, so review the lease and then review the statute. If you're dealing with a casualty loss issue, like after a storm, something like that, oftentimes there is legal assistance available. So, please reach out to us to apply for services or, talk to one of the other groups that does disaster relief law. Now we kind of get to the meat of what normally happens in eviction, which is early termination due to a breach of lease. So this is the right of the landlord to basically terminate the lease if something has gone wrong. So some violation of the terms, the conditions, the rules, or provisions. These are defined by the lease. So again, review the lease. Some common defaults that we see, the most important one, biggest one, is the failure to pay rent by the date stated in the lease. We do see violations of community policies. Sometimes you see unauthorized tenants being defined as a violation of the lease, criminal activity, and then technically holding over is also considered a breach of the lease. Although, again, that can be broad as simple holdover. If a breach of the lease occurs, before the landlord can run off to file an eviction, they have to give you notice that there's been a breach of the lease and they're terminating due to the breach of the lease prior to filing an eviction. Some special things that we see sometimes in eviction cases. One is withholding rent. So the way this normally plays out is you've got a tenant, they're in a property, something in the property breaks, and they request repairs, and the landlord refuses to make the repairs or doesn't do it in a timely manner. And the tenant, believing that they're not being served, they withhold the rent and tell the landlord, we're not paying until these things are taken care of. Do not do this. Self-help is not allowed in this manner. Texas law requires rent to be paid in full and on time as it comes due, regardless of whether or not the landlord is meeting all their obligations under the lease. Withholding the rent could subject you to an eviction for non-payment of rent. It often does. Additionally, there is a separate sort of legal uh, cause of action that you can raise if you are dealing with a failure to make repairs issue. Um, you have to be current on rent in order to bring that lawsuit or in order to even ask for the repairs. Once you fall behind, your landlord doesn't have to fix anything in the apartment. If you are facing an issue where the landlord's not making repairs, there is a process for, basically asking for them to set up your lawsuit. The first thing you want to do is you want to send your landlord a written request. You want to send it to them via certified mail. And you need to wait a certain period of time, reasonable period of time before you can sort of take the next step. Reasonable under the statute is considered 10 days, it's presumed. There are instances in which that time might be less if it's an issue that materially affects someone's health or safety. It could be longer depending on the availability of workers to actually deal with the issue. So if you're talking about right after a hurricane and there are contractors and they're all tied up in different things, holding the landlord to 10 days may not be reasonable. It's a fact issue that the court would have to decide. If you send out the written request, and nothing's happening, at that point, we recommend contacting a lawyer to assist with next steps up to and including a lawsuit. Additional thing to note about a lawsuit and an eviction suit is that at eviction, you're not allowed to bring counterclaims. So if you have a repair issue, that has to be brought as a separate lawsuit. It can't simply be attached as a counterclaim to an eviction. Second sort of special case that we see sometimes, not as often as withholding rent, but still often enough we want to talk about it. What happens if you as the tenant go to pay your rent and it's in full, it's on time, but it's refused? Landlord is not free to refuse properly tendered rent under a lease agreement. They're allowed to tell you what the manner they want the rent to be paid in is. So for instance, if they require a money order as opposed to cash, they're allowed to do that and refuse cash. But if you're following the lease and you're making your payments timely, they can't simply refuse it. If you're in this situation, some things that you should do. First, you want to review your lease in a current ledger. Make sure that what you're offering the landlord covers all amounts owed. So remember, we said that under the lease, they can take your money and they can apply it to other things, or they can determine that, rental payment without utilities, that it's not payment in full. These are all things that we've seen people trip up on. So you want to make sure that covers the rent, it covers any fees that might be owed, covers utilities, and it's being offered again in the manner consistent with the lease. Assuming that's correct, you want to document the date, time, and manner of the payment. So basically, you want a record that shows that you did, in fact, offer the rent to the landlord. By offer, I mean, you actually, had it been accepted, the landlord would have had the money. We're not talking about emails or, anything like that, but you want to do everything you can to put the money in the hands of the landlord and have them return it to you. You want to document any correspondence you have with the landlord. I mean, most people, if the rent is refused, they're going to reach out to the landlord and ask what's going on. Anything like that that you can document, put in writing, is going to be helpful. You want to keep the payments or funds available for potential future payments. If there is a dispute, doesn't necessarily mean that those amounts aren't owed. And so you want to have those funds available to retender. If this is a situation that goes on a few different months, you want to continue to offer the rent in full and on time for those future months. And then, really important, contact an attorney for assistance. As sort of a final note on this, sometimes we see instances in which there are disputes about what's actually owed under the lease. Either the landlord has a fee that the tenant may not know about, under the lease, or is surprised by, or there's some dispute about things. Usually in these cases, it's better to tender the full amount that the landlord is asking for and then sue them on the back end than to make what the landlord considers a partial payment and then deal with this through the eviction context. One puts you in a defensive posture and makes it a lot harder to win, and the other gives you a lot more flexibility in terms of sort of getting restitution for any issues. So, that would be a recommendation if you're dealing with that issue. So notice to vacate after a breach of the lease is sort of the first document that most people deal with in the eviction context. It's the notice that they have to give prior to the filing of any eviction. Property code specifies that notice must be in writing. The property code sets the timeline as 3 days notice in order to evict someone, although it's important to note that that timeline can be changed by the lease. And so standard Texas Apartment Association leases, for instance, only require a 24-hour notice to vacate. The property code also defines what proper delivery looks like. And this is, if you take nothing away from this, this is a really important, part of this process. Notice to vacate must be delivered in one of only a couple ways. The first is hand delivery. So your landlord knocks on your door, you open it up, and they hand you the document. They can mail it to you. So that can be sent by either regular mail, registered mail, or certified mail. Or they can post it on the inside of the door. So open the door, put the notice with tape on the inside, and close the door. That's valid notice. The property code also allows for a notice to vacate to be delivered through an alternative service method. In those instances, the notice has to be put in an envelope affixed outside the door. Envelope has to have certain things written on it. Has to be posted firmly fixed to the outside of the door. They then also have to mail a copy of the notice to the tenant, and it has to be mailed by 5:00 p.m. the same day. Keep in mind, the landlord has to prove to the court why alternative service is required in order for this to be available to them. Really important, if you're a tenant and you think you might be facing an eviction and you haven't gotten your notice yet, keep your eyes open. If something is delivered to you, you want to take steps to document exactly how it was delivered. If you find something on your door, you want to take a picture of it before you touch it. If you get in the mail, you want to know when it's been delivered to you. All these things are important, and an eviction can succeed or fail based on whether the notice has been properly delivered. And, good documentation can be a difference between you winning your case and you losing your case. I briefly want to talk about the CARES Act. The CARES Act was a federal law that was passed during COVID, originally provided for a moratorium on evictions, but also created a right to a 30-day notice for people who live in certain covered properties. So covered property basically refers to a property that's either covered program under VAWA, a property that gets federal funding through some subsidies. So for instance, Section 8 or low-income housing tax credit properties, or it can be a covered property if it is receiving a federally backed mortgage through Freddie Mac, Fannie Mae, the VA, or a Fair Housing Act. Covered properties can include homes, single-family homes, duplexes, mobile homes. What's key here is it's covered because of the relationship between the property and the some federal subsidy. If you're living on a covered property, you do have a right to get a 30-day notice, not a 3-day notice or a different amount of time as stated under the lease. Now, I've mentioned that there's the possibility of laws changing. There have been certain proposals which would end the 30-day notice requirement. So just be aware this is a part of the law that could change very quickly. We also recommend that if you think that you are in a covered property under the CARES Act, that you reach out to an attorney and get further assistance. If you're going to know if you're on Section 8 housing. So that's not really an issue, but you may not know if your landlord has a federally backed mortgage. And some of that information can be searched publicly, but some of it is harder to find. So we'd recommend if you think that you might have a CARES Act issue, that you reach out to an attorney for assistance. So we've seen the breach of the lease, we've seen the notice delivered. Now we get to the actual lawsuit itself. So an eviction is what we refer to as a forcible detainer suit. The primary focus of any eviction is the question of who has the greater right to possess the property. The main things that a landlord has to prove, they have to show ownership of the property. They have to prove up a breach of the lease or some termination at the end of the lease term. They have to show that the notice to vacate was properly delivered. And they have to basically show that the defendant did not leave prior to the expiration date of the notice. In non-payment of rent cases, the landlord can ask for both possession and add a claim for the back due rent amounts. Keep in mind, the landlord can only ask for the base rent. If you're in a property that you pay for utilities separately, or if there are late fees or other sums that might be owed, the landlord may still be entitled to those, but they can't get those in an eviction lawsuit. Now, we're sometimes asked about jury trials. Most evictions are going to be tried via we call bench trial, which means the judge basically hears the case and they're the one who makes the final decision. If you are in an eviction and you want to ask for a jury trial, you have to file a jury demand and you have to pay the required jury fee 3 days before the trial in order to be entitled to a jury. If for some reason you do that and you're denied a jury trial, that's an instance in which you want to contact a lawyer and ask for additional assistance. So all evictions are initially heard in what we call justice courts. There are 16 of those in Harris County. They're in sort of divided into 8 precincts. Each precinct has 2 courts in it. If you live in the precinct, the landlord can choose to file in either of the JP courts in that, by what we call justices of peace courts, JP courts. You know, just so if I say JP court, you know what I'm talking about. The landlord can file in either of those places. So oftentimes you'll see instances in which someone will be sued in a court that's further from their house than the other court. Be aware that's allowed. Justice courts use simplified procedural rules. They don't need to follow the rules of evidence. And so what you actually see in justice courts actually can vary quite a bit from court to court, even in the same precinct. If you're sued and you're showing up to your court date, some things you need to know. We recommend trying to show up early to trial and have everything you might need that day. Some reasons why is some courts do have resources available for tenants. Those can include people helping with rental assistance, people like our firm who sometimes provide legal representation, advice on the spot. Also sort of a hedge against Houston traffic, making sure that you're not missing your court date. When you get there, you want to check in. Sometimes you have to check in with the clerk directly. Sometimes you'll be told that the court will, what they say, call docket, where they simply read out the names of everybody who's supposed to be there, and you basically put the court on notice all at once that you're there or not. If you have questions, ask the clerks. They're there to help you. Prior to trial, some judges give instructions on how the court works. So if they give sort of an introductory speech, then you want to pay attention to that and listen. Some judges do require that prior to the eviction case being called, you have to talk to your landlord to see if you can settle the case. And I believe we'll talk about that next. But just be aware, in some cases, you're going to have to talk to your landlord, see if you can work something out. If you can't work something out, the case gets called to trial. At trial, most judges will begin by hearing the plaintiff's case. and letting them sort of put on all their evidence before giving you an opportunity to respond. Some judges will direct you to have an opportunity to cross-examine the landlord. Some will simply listen to the landlord and ask you to put on your case. You want to make sure that you're prepared when this case gets called to trial to answer any of the judge's questions or provide evidence. The judge's role in this process, like I said, is a lot more informal than you see in the county court, which is the next step. And judges, are usually pretty involved in the trying of the cases. So, just be prepared to interact with the other side and interact with the judge, answer any questions, and then, again, make sure that if you have any evidence for your defenses, that you have those available to show the judge. And we usually recommend having those printed out. Some judges are fine with electronic evidence. Some judges, they want to see something actually printed. We do get questions about resets. Oftentimes, tenants show up and, they want to move out, but they need a little bit more time and they want to know if they can get a reset. Trial can only be reset either by motion of the plaintiff or if both parties agree to continuance. So the judge generally doesn't have discretion or the authority to reset the case. There are certain instances in which they might if something needs to happen, but like I said, usually you can't just go up and ask the judge for more time. At the end of the trial, judge is going to issue a judgment in favor of one party or another, or they may dismiss the case. That'll tell you sort of what the final disposition is. If you have any questions about what that is, you want to get a copy of the judgment, either from the judge or the clerk. So you can go to the clerk and ask for a copy or ask for additional information. And sort of the final note on this, courts can be very stressful for all parties involved. It pays dividends to keep your cool, to not get emotional, not get angry, and basically to treat everybody involved in the process with respect. So, be respectful to the judge, be respectful to the other side. And even if you're mad at the landlord, just, it's important you keep your cool and not go off on them. So as I mentioned, a lot of judges like the parties to talk to each other prior to trial to try and see if there is some form of settlement. Even judges that don't sort of facilitate settlement agreements do often like it when the parties sort of solve their own issues. So we want to spend a little bit of time on settlement agreements. The settlement agreement is basically a mutual and a binding agreement between the parties, basically to figure out what the end of the case is going to look like. So instead of going and having the judge decide what the end looks like or deciding a winner, the parties basically say, here's how we're resolving the issue. It's important to note that, like I said, it's a mutual agreement. Both parties have to agree to the terms in order for an agreement to be binding and enforceable. You can't simply say, well, I want this, and expect that the court is going to honor that without the other side also agreeing to those terms. Some judges, beyond just encouraging the settlement, they sometimes provide resources to facilitate settlement, such as standard settlement forms, or a couple of courts actually have mediators who are available to the parties. Keep in mind a few things. Like I said, a settlement agreement has to be between the parties. It also has to be in writing. A good settlement agreement is going to clearly define the action to be taken by either party. So if you're trying to settle a case, usually it's going to be very specific in terms of what either side needs to do. If a court provides a standard settlement agreement, it's important that you review it and make sure that it reflects what the agreement might be. So what sort of agreements might we be talking about? One possible agreement is a payment plan. So, you owe your landlord rent. The landlord wants you to stay, but needs the rent to be paid. You either have an agreement whereby the tenant pays everything to the landlord upfront, or you might have something structured where the tenant pays a portion to the landlord on a particular date and then more at a different date. If you're going to go down a structured route, you want to make sure the settlement agreement is very specific about what is owed and when. The other settlement agreement that we see that is most common is what we call a move-out agreement. So one party says, I will move out on a particular date. And if I move out by that date, then the agreement is that the case against me will be dismissed. Most standard settlement forms are going to refer to sort of the latter form of settlement. We normally see move-out agreements. Payment plans are a lot more rare. So if you are agreeing to a payment plan, it's important you review the terms that you're signing on to and make sure that they reflect what's actually happening, and that you're not agreeing to make payments and then also to move out, which we sometimes see. Again, keep in mind, settlement must be in writing, signed by the parties, filed with the court. Anything that's informal and written is not going to be honored by the court. And then finally, keep in mind, a settlement is going to involve the parties giving up rights, or it may impose penalties if a party fails to comply with the agreement. So let's say that you're a tenant and you're agreeing to move out on a particular date, and you're not out on that date. Usually the settlement agreement will provide the landlord the right to get judgment, and oftentimes will allow them to get an immediate writ of possession. So whatever you agree to, make sure it's something you can actually do. Don't bet on, just getting more time without a plan. You want to make sure if you're settling that you have a plan so that you're not also facing judgment at the end of the process. So let's say that you have a case in the Justice of the Peace Court and you lose. You do have the right to file what we call a de novo appeal to the county court. Basically, what that means is that a higher court will hear the case all over again from the beginning. Important to note is that county court is not like justice court. We'll talk about that in a minute, but you're talking about a court that is more formal and has more rules in terms of what you can bring and what you can't bring. So there are times in which the Justice of the Peace Court is a friendlier venue to the tenant or the landlord, and there's times when the county court is actually the friendly venue. So deciding to appeal, could have some different tactical or strategic implications. So if you have questions about what to do, you want to talk to an attorney. Now, in order to appeal a judgment, you have to either file something called a statement of inability to afford court costs or appeal bond, or you need to pay something called the appeal bond. Either of those is due within 5 days. The appeal bond is set by the judge in any case. Usually it's set at 2 months of rent. Most people can't afford to simply pay 2 months of rent upfront, which is why the statement of inability is what we see used to appeal these judgments in most cases. The statement of inability is supposed to be available at all the clerk's offices, so you can go and get those, fill those out. And again, you have 5 days to file that. If you do not file the appeal within those 5 days, at that point, the judgment becomes final, and a writ of possession, which is the document that allows the landlord to retake their property, it can be issued at that time. If you file an appeal, within 5 days of filing the appeal, if you're being evicted for non-payment of rent, you have to make a payment of 1 month of rent to the court registry. You're also responsible for paying rent in full and on time as it comes due to the court, so long as you intend to stay on the property. If you don't pay rent to the court registry, either in deposit or those subsequent payments, you're still allowed to stay. Sorry, you're still allowed to appeal, but the landlord can say that you're not allowed to stay, and they can ask for the writ of possession at that time. Keep in mind, statements of inability, you're basically providing information about your income, your assets, any debts you might have. Those forms have to be signed under oath. And in a lot of cases, those statements can be challenged. If you're in a situation where you're appealing via statement of inability to afford court costs and you find out that there's a challenge to that, you're entitled to a hearing in front of the court. Basically, you have to show court evidence that the information in the statement is true. If the judge sides against you, you do have the right to appeal up to county court to basically ask that that be reconsidered. If you're in that sort of situation, that's another instance in which I think it's really helpful to have an attorney to provide additional information to walk you through that process, if not to step in to help you appeal altogether. Once the proper forms are filed, um, the case is transferred up to the county court of law. It's then going to be assigned to a specific court. Here in Harris County, we have 4 county courts at law. We also have an associate judge who hears most of the evictions. So most will go through the associate judge prior to any sort of presiding judge. You want to make sure that you're checking your mail regularly once you appeal, because you will receive paperwork from the county court. That'll give you information about your court date, which court it's in. It'll give you a new cause number, which is the number that you use to track your case. It'll also ask that you file an answer. We do recommend filing an answer, although if you have appealed via statement of inability, that can count as an answer. So just be aware, we recommend the answer, but in certain instances, a statement should be good enough as well. So when you're in county court, again, the case is heard de novo, which means from the beginning. So anything that happened in justice of the peace court isn't going to be relevant to county court. Your landlord has to prove up their case all over again. County courts of law, they use formal rules of procedure and evidence. Evidence needs to be filed in advance of trial. Like I said, in the associate judge's court, that means Wednesday prior to any trial date. It then has to be introduced to the court in order to be accepted. Like I said, justice of peace are not courts of record. County court is a court of record, so you shouldn't need to tell the judge what happened in the lower court. The judge is going to hear it from the top again. Make sure you're paying attention to what the plaintiff is doing. They also have to prove up their case. If they don't testify that they delivered a notice to vacate properly, or they leave out information, sometimes that's enough that they lose their case. Keep in mind, too, that the landlord must prove out their case with both testimony and evidence. And oftentimes, there's a question of whether somebody either has personal knowledge of what they're testifying to, or whether what they're providing is hearsay evidence, which means it's an out-of-court statement. So it's a lot more formal. If you have issues with this, again, this isn't part of the process where it really helps to have an attorney either walking you through it or representing. So if you're looking at this, you may want to apply for services. If you are unsuccessful in county court, there is a process by which you can ask the presiding judge to reconsider the case. You have 7 days to file that request. You have to give basically, specify what part of the case you want them to look at. So if there's an issue with the notice and you dispute that the notice was properly delivered, you want to specify that in your notice. If you want to skip that, there is also an appeal available to the Court of Appeals, but it's not the same sort of appeal as to county court. Appeal to the Court of Appeals is not a de novo appeal. Basically, the Court of Appeals is reviewing the record for any errors that the lower court might have made. So any sort of appeal would need a record in order to be successful. It would also require the payment of something called supersedeas bond in order to retain possession. And that's a significant amount that can't necessarily just be waived by another statement of inability. So normally, county court is the last stop along the route. But if there is a real issue and you have an attorney representing you, they can provide additional assistance if there's a need to appeal it up to the Court of Appeals. In all cases, you would have 10 days to pay a supersedeas bond. Usually, a writ of possession is not issued during those 10 days, although there's certain instances in which it can issue previously, though. Keep in mind, too, some courts will allow for immediate writ of possession if you don't make your monthly payments to the county court registry. So it's something else to keep in mind when you're planning ahead. Let's talk briefly about public housing and subsidized housing. As we've mentioned, the lease agreements can significantly alter the rules that landlord or tenant has to play by in the eviction process. And public housing, this is especially true. Any requirements, additional requirements about either termination of the lease or changes in timelines, those are going to be spelled out in the HAP contract and federal regulations. These can differ from program to program. The Section 8 rules are not the same rules as are used by, for instance, low-income housing tax credit properties. Keep in mind that evictions involving public housing, these can also involve the termination of housing benefits, particularly if you're on a Section 8 housing voucher. So you want to keep an eye open for any notices from the housing authority about your benefits. Keep in mind, public housing beneficiaries are always going to be covered by CARES Act protections. If you're on Section 8, it's a federally bad property, you're entitled to a 30-day notice. If you're on a low-income housing tax credit property, you're entitled to notice under the CARES Act. If you're facing an eviction and you're appealing and you're on public housing, and I mean specifically Section 8, you're only responsible for paying your portion of the rent to the court registry, even if the landlord is getting additional payments from the housing authority. Sometimes what we see is you'll have an instance in which the landlord's payments from the housing authority will be terminated due to the property failing inspection. And the landlord will try to basically demand that the tenant pay the entire rent, or they'll go to court and they'll leave out that the tenant is only required to pay a certain amount under the HAP contract. If the court orders in those cases that the full amount of rent be paid into the registry, you have the right to file something called a rent contest within 5 days of the judgment. What you're going to want to do is provide the court information about your housing contract. You're going to want to provide the correct amount that you would need to pay. And, the court is supposed to set a hearing date and basically consider that. And again, if the court decides the wrong way, decides you have to pay the full amount, you do have the right to appeal to county court. This is another instance in which we highly recommend, if you can, to get counsel to assist. So that sort of wraps up specifically the eviction side of things. We'll now turn briefly to what else might happen if a lease agreement is breached, and some of we'll call them self-help remedies we sometimes see landlords engage in. The first of these are lockouts. Those are where a landlord simply decides that they're going to exclude a tenant from the property or change the locks on them so they can't access the property. This comes in two varieties. There's one that is authorized under the property code, and then there's the other, which is basically a wrongful eviction. And we'll sort of talk about a little bit about what either one looks like. But suffice it to say, there's no version of a lockout where a tenant can be permanently excluded from the property without some form of court order. The second sort of self-help remedy we sometimes see are utility shutoffs. In order to force a tenant out, the landlord is going to interrupt either water or electricity. Again, there are very rare instances in which a utility shutoff can be justified, but in most cases, a utility shutoff is going to be unlawful. Aside from those, the landlord may, in some instances, exclude somebody from the property for bona fide repairs, construction, emergency. So just be aware, those are temporary instances. If there's a question about whether it's legitimate or, not a bona fide repair, construction, emergency, talk to an attorney. So let's say that you're facing a lockout utility shutoff. What you want to do is you want to make sure, first of all, that you secure yourself so that you're not simply, homeless. Usually recommend, finding some place to stay and then reaching out to us, try and get emergency relief. The two lawsuits that you can file. If it's a lockout, it's something called a writ of reentry. If it is utility shut off, it's something called a writ of restoration. Both of these operate very, very similarly. They're just a sort of a different name for a similar process. If you're locked out, you do have the right to get a key to the property, basically with a specific period of time. Actually, let me move on to the next slide before we start talking about that. So let's say you've been locked out. Landlords change the locks. Under the property code, they have to give advance notice. They also have to allow you to request a new copy of the keys. And once a request has been made, they're required to provide you a copy of those keys within 2 hours of making the request, regardless of the time of day. This is why we don't normally see lockouts, is because most landlords sort of understand that if they lock you out and it's 4 a.m, you come home and you can't get in, and they make a request and don't get the keys to you in 2 hours, they have real issues on their hands. The landlord also cannot demand payment in exchange for a key. If your landlord fails to let you in or you remain locked out, like I said, there is what we call an ex parte lawsuit available called a writ of reentry. Basically, you're filing a request with the court saying that I rent this property, the locks have been changed, I can't get back in, and you're stating to the court under oath that those facts are true. You file the lawsuit, the court sets an initial, we call an ex parte hearing. Ex parte basically means that you are talking just to the judge. You do not need the other side present in order to have your case heard. Although it's usually best practices to put your landlord on notice that you filed and that you have a hearing. If the judge agrees you were legally locked out, they issue the writ of reentry, which basically directs a constable to go to the property with an order that allows you to re-enter the property. If you've been locked out, after you've gotten your writ of reentry, you can file a separate lawsuit asking for any damages that you might have incurred. So, for instance, there's a penalty of 1 month's rent plus $1,000. Any actual damages that you might have had. So, for instance, if you had to get a hotel room or go to a restaurant to eat because you couldn't cook at home, you could be entitled to getting compensation for that. You're also entitled to court costs and reasonable attorney's fees, less any sort of amount for delinquent rent or other sums. You also have a right to early terminate the lease if you've been locked out and have to re-enter via writ of reentry. Again, utility shutoffs are basically the same. You file a writ of restoration with the JP court in the precinct where you're living. You state the facts. I live here. Utilities have been shut off. There's no legitimate emergency. I've asked the landlord to turn them back on. They refuse. Case will be set for an ex parte hearing. Again, you don't need to serve the landlord prior to the hearing, although best practices is to put them on notice. If the judge agrees utilities were disconnected, you'll get a writ of restoration where the constable requires the landlord to turn the utilities back on. It's then served on the landlord. Once things have been restored, you can recover actual damages, $1,000, attorney's fees, and court costs, less any delinquent rent or other sums due to the landlord. The one thing about utility shutoffs that's a little bit different from lockouts is that normally for utility shutoffs, there's a question about whether there is a legitimate need for repairs. Because again, if basically your landlord is contracting with somebody to provide repairs, they do have the ability to shut off the utilities. Or if there's an emergency to shut off the utilities, that's also allowed. So just be aware. Oftentimes there are fact issues involved in this particular cause of action that you're going to want to account for. The last thing to talk about are security deposits. We often get questions about these. Your landlord is allowed to keep and deduct from security deposits any amount for damages or charges for which tenant is liable during the breach of the lease. So for instance, if you're living somewhere and you put a hole in the wall, they're allowed to deduct the amount to repair the hole from the security deposit. If you're living somewhere, you fall behind on rent, you move out, the landlord can retain the amount that would have been due in rent from the security deposit. Assuming that there's money left, the landlord has an obligation to refund that portion of the security deposit on or before the 30th day when you surrender the unit. Keep in mind, the landlord cannot retain any portion to cover normal wear and tear. This is often a fact question, but when you live somewhere, as you know, things wear out over time. If something is damaged, but it's not your fault, it's the result of something being old. The landlord can't simply deduct the amount to replace the item from the security deposit. If your landlord is going to keep all or part of security deposit, they are required to send you a written description and itemized list of deductions, unless the tenant owes rent. There's no controversy concerning the amount of rent owed. If you are in a situation where you think that you are supposed to get something back for your security deposit, the first step is to give your landlord a forwarding address so they can either send you the deposit or send you a list of deductions. Their timeline actually begins once they have that forwarding address. If by the 30th day you still have not received either the list of deductions back or the refund, you can take steps which will eventually result in a lawsuit. So best practices are to send another demand letter asking for either the list of deductions or the deposit back, and if they don't respond to that, at that point, you may have a lawsuit that you can file. It should be noted there is a presumption if security deposit has been wrongfully withheld if the landlord does not provide you that list of deductions within the 30 days. So oftentimes landlords, this is a particular cause of action where the presumptions actually work in favor of the tenant. Now, some best practices, if you're moving out and there's a question about whether their landlord is going to wrongfully withhold the deposit, schedule a walkthrough with the landlord so you can document any sort of damages that might have occurred or might not have occurred, and keep basically the result of any documentation for your records. If you receive the list of deductions and you disagree, that also allows you sort of the ability to seek to file a lawsuit to recover the amount wrongfully withheld. And again, this is one where if you file a lawsuit and you win, you are entitled to attorney's fees. So if you can get representation, oftentimes it pays dividends to have somebody helping you out. So just some additional tips before we move on to questions. In landlord-tenant contacts, it usually helps to try and communicate with your landlord early. Even if you can't resolve the problem, at least gives you a sense of where things are going and assists you for planning for the future. So once a problem arises, talk to your landlord as soon as possible and see if you can work it out. There is still some rental assistance available if you're falling behind on rent. Contact the local services and local organizations as soon as possible to try and get that ball rolling. Oftentimes, landlords are more willing to accept rental assistance if it basically is offered for earlier in the process. If you're having problems with the condition of the unit, make sure that you pay your rent and then contact somebody to help with the repair and remedy suit. As always, if you're in doubt about any of your legal rights or issues, ask for help. Aside from my group, there are other groups that are doing work like this. Make sure you go to the credible groups, though, such as Lone Star Legal Aid or Houston Volunteer Lawyers, whenever you're seeking assistance. Sometimes you'll get mailers from different groups. They're not always credible. So just make sure you do due diligence when you're seeking representation. And with that, here's some information if you need to apply. We have you either go to our website to fill out an application, or you can call either of these numbers. If there are any attorneys here and you have questions, you can always email me. If you are having to represent yourself pro se, Texas Law Help is a great resource. It's maintained by the state bar, specifically to help out people who, for whatever reason, aren't represented. And it's incredibly, incredibly useful. So that's another one that you may want to bookmark. With that, I'm ready to take any questions you might have.
Let's see here. Question here. Can you hold the security deposit during the application process? Can they hold the security deposit during the application process?
Um, I'm not sure it'd be a security deposit at that point. I mean, they may be able to take an initial deposit up front. I assume that would be refundable. I mean, the nature of security deposit is that it is an amount that is basically accepted and held by the landlord to cover any sort of damages to the property, and by its nature, it's refundable. So, I mean, could they ask for a deposit up front? Possibly. But I'd have to look at the specific language to advise further.
So it wouldn't necessarily be a red flag if somebody's requiring you to pay a security deposit before you even get your application approved?
I mean, it's a red flag for sure. I'm not sure it's unlawful. I'm not sure, like, I'm not sure that you could sue someone over it. Although I'm sure you'd be able to sue them if they took a deposit and refused to return it. What I'd say is that if you're considering paying an early deposit, this is going to be another instance in which written agreements are going to be really important. So you want to make sure that it is refundable, that you have the information needed so that if it's not returned, you can go after the landlord who's wrongfully holding it. I can't say I've seen that fact pattern very often. Um, but yeah, I mean, if the question is it a red flag if someone is asking for me to put a massive deposit down up front? Yeah, I'd have some questions. Is it necessarily unlawful? I don't know that it is.
Um, Another question here. Can an eviction judgment be reversed if there is an arbitration clause in the lease agreement?
That's a really good question. The answer is probably no. If there's an arbitration clause in the lease agreement, the proper thing to do is to basically ask the court to refer the case to arbitration. I've actually seen some cases where there are certain, uh, excuse me, there are certain leases that require disputes be arbitrated. Now, the thing about arbitration clause is that arbitrators are not free. Arbitrators can get very expensive. If you're thinking about asking for arbitration, you want to know who's responsible for those costs. Because if you ask for arbitration, but you can't afford the arbitrator, there are going to be issues there. Another thing is that a lot of arbitration clauses will make exceptions for certain sorts of courts or certain sorts of causes of action. So one that I've seen basically says that you can't ask for arbitration in a small claims court, which would basically mean you could not compel justice of the peace court to refer to arbitration. That's different in county court, where you could ask for that referral. So a lot of it depends on the specifics of the arbitration agreement. But if you're asking, if after there's a judgment, can I basically have the judgment thrown out? I mean, the only way it might work is if you're in the court's plenary power and you ask for reconsideration. But normally speaking, once a judgment has been entered, if you haven't raised those issues yet, it's going to be considered waived.
So find out before you even start to go to court, basically.
Well, so the ones that I've seen in the past, and I'm not going to get too specific, but there is a company that does rent to people that does have an arbitration clause that would apply to eviction appeals. And how we've handled those is that we have filed before the county court at law trial a motion to stay the proceedings and compel arbitration. And so basically you're saying before the judge sees it or hears it, you're basically putting a motion on file to say that there's an agreement that requires this case to be arbitrated. And best practice would be to ask for a hearing on that clause prior to any sort of trial.
Gotcha. See what else is here. Okay. Doesn't it mean a breach of contract if the lease agreement states any claims or disputes to arise should be resolved in arbitration? Oh, I think you answered.
Yeah, and just to sort of reframe this a little
Okay.
bit, an arbitration agreement basically sets out a procedure that can be used to solve certain disputes. Parties can waive that if they want, or any party can basically go to the court and say, we have this dispute, we're required to do it through this process. And so it's not like a breach of the lease where, you necessarily sue somebody for it. But it's something that during the process itself, a party could exercise the right to have the issue referred to an arbitrator.
So in that regards, it should be defined then who would be responsible for the payment, or right? Or like who pays for the arbitration? Would
Um,
it would it be then
so
spelled out there as well?
so the ones I've seen have specified who's going to be responsible for making payments. Um, again, it's something where if this person is dealing with this, I would highly recommend applying for services so that somebody can put eyes on the agreement itself. A lot, alternative dispute resolution has been a big trend in law to try and get cases sort of out of we consider normal regular courts and sort of into these different sort of alternative courts, try and speed up the process, get better, at least in theory, better outcomes for all parties. And so there's a lot that parties can agree to and a lot that will be deferred to the parties' agreements by the courts if you're talking about one of these clauses. So the actual language used, what specifies, probably more important than anything I'm going to say today, in terms of that issue. You're going to want to review it. If possible, you're going to want an attorney to review it and let you know sort of what your rights are. And, it might be that, it makes sense to use arbitration to solve the issue. It might be that you want to stay away from arbitration. It really depends on a lot of things that I can't speak to without reviewing the actual clause.
Okay. I have a question that was a couple of questions that were emailed to me in advance, and it looks like it says, I have an eviction on it. I think she meant on her record, but was never actually evicted. Um, the issue is still on public record, and it was dismissed. I paid the rent before the court case took place. So how do you get it off your record?
Um, let's kind of go through that in detail because I think I heard it, but I want to make sure I'm answering specifically. So there's an eviction filed.
Mm-hmm.
The tenant paid their rent. Did they say there's a judgment or
It said it was dismissed.
okay, so it's dismissed. There's just a record of it being filed. It sounds like they're dealing with.
Say I paid the rent before the court case took place. So how can I get it off my record? Yeah, it looks like where the eviction was filed is.
I'm gonna reshare this
Yeah,
screen.
I'm not sure where that would show up at then.
So a lot of people think that when you talk about an eviction being on your record, that what you're referring to is you've lost a
Election.
court case and that judgment becomes your tenant history. And that's not entirely accurate. It's true that any tenant screening is going to pick up on a judgment, but they also report the filings themselves. And this is where things get kind of complicated because a filing is public record unless and until a court chooses to seal the record. during COVID, we had a procedure by which certain tenants or certain defendants could have their cases sealed. Um, when the emergency orders for COVID went away, that procedure mostly went away. There's some courts that I understand still do it, but it's it's not common. But the thing is that the sealing of the record only means that's inaccessible. It doesn't mean the filing itself never happened. And this is sort of a loophole that allows tenant screening groups to report the filings no matter what happens. And so sealing is probably not available. And then the fact is, even if it was sealed, don't think that you could compel any sort of tenant screening group to remove that from your record. Now, if they're being denied housing because of this eviction, it makes sense to ask for a copy of the tenant screening report to see if the record is being reported accurately. So sometimes what you'll see is, I've unfortunately had to deal with this in a couple of cases, the tenant screening report will inaccurately report the outcome of the case. So they'll say, for instance, this case, which was sent up on appeal, was decided in Justice of the Peace Court against the defendant, when instead it was sent up and the defendant won. So what you want to do is you want to get a copy of the tenant screening report. The first step to doing that is you ask whichever landlord refused to rent to you for what we call a declination letter, where they basically disclose which tenant screening report they used. And then you would have the rights to contact that company and get a free copy of that report within, I can't remember if it's 30 days or 60 days. I think it's 30 days, but the letter should specify that.
But
You
the
get the
property
copy.
management company is not required to give you a copy.
Well, sometimes the property, they're using an online portal, they're using something. They're not required to give it to you, but they're required to give you the information of how you can get it.
Okay.
And if you have difficulty sort of getting them to move on that, that's a consumer issue. That's something where you want to contact an attorney for assistance.
Now, the tenant screening is not the same as them looking at the credit report, though.
It's a little bit different, but it's a similar sort of concept. The big difference between tenant screening versus normal credit reporting is I think that credit reporting is a lot more strictly regulated than tenant screening. That said, if the tenant screening report shows inaccurate information, you do have the right to contest it. So, for instance, if it shows a judgment when the case was actually dismissed, you can basically, write to them and ask them to fix the inaccurate information. And then there may at that point be a cause of action. It's important if you're facing these issues to sort of document if you're having damages. So for instance, if you put down like an application deposit or application fee and it's not returned to you because you were denied because of this inaccurate information, that could form basis for damages if it ever actually gets to a lawsuit. But I mean, the key thing is you're going to need to get some more information to know what you're dealing with before you can simply assume that, it's inaccurate information. But sorry, you
So,
look.
yeah, I'm just trying to kind of drill a little bit deeper into the tenant screening versus the credit report. So, because I know that evictions are not reported on your credit report, it's the collection for whatever unpaid rent that gets reported. So, on a tenant screening, if someone sees a tenant or what's reported to a tenant screening, is that you have an actual eviction, or is it the collections that they see on a tenant screening report?
It's an actual eviction. So
Okay.
what a tenant screening report is, it's like a credit report, but instead of the company wondering if they're going to lend you money, it's the company wants to know whether or not you'd be a good tenant. Like I said, credit screening is pretty strictly regulated relative to tenant screening, which allows reporting of a lot more things. What's relevant in the eviction context, like I said, are sort of that record of what cases were filed against you.
Mm-hmm. Yeah, I wanted to make sure that people really got a good understanding of that, because I know that sometimes what people will say, or because I've had clients, real estate, that will
Okay.
say, well, the eviction's not on my credit report. Well, yeah, the eviction's not on your credit report because there was no actual collections. I mean, your rent was paid, however, or you paid or settled it or whatever afterwards. So the collection is not there. However, because of tenant
Mm.
screening, they could see where you were still actually
Yeah.
evicted from the
Yeah.
property.
Yeah.
So
And keep
two
in mind
different things.
keep in mind one of the big things there is there are evictions where there is no money
Hmm.
involved, where you're not going to have, so for instance, a conduct-based eviction, they're not going to have a claim for money, or a holdover, they're not going to have a claim for money. Um, Look at the chat. Ebony, you asked the question. I'm going to recommend that you apply for our services. Hang on. I can't guarantee anything, but it sounds like you have a specific set of facts that we would need somebody to look at and provide specific advice in order to deal with the issue. Um, so just, okay. Are there any other questions?
Yeah, there was another one that was emailed to me too, and this one sounds a little bit creepy. I found my landlord repeatedly spying on me and suspect strongly that they have been going through my personal property inside the home. In addition, I caught the landlord's husband spying on me from in the bushes. I also found small cameras in the smoke detectors in the home. I do not understand my rights under Texas law regarding how much privacy I am entitled to, nor have I reported anything. So what actions can be taken place if a tenant finds themselves, if their privacy is being violated by a landlord?
One thing may be to contact the police and file a report. Um, I can't say that I've ever had to deal with a tenant privacy issue like that. Um, it certainly seems rather extreme, but the thing about law enforcement is that if you feel unsafe, they can provide some form of relief. Um, I mean, this is another one where you may want to apply for services. I can't say that I've dealt with an issue like that. No privacy law well enough to provide any sort of additional information.
Would that be grounds for somebody breaking their lease?
I actually don't know. I mean, usually, is that one of the grounds for early termination that we talked about? Um, it's possible there's something in the lease agreement that might provide greater rights to an early termination, or there might be some federal privacy law that I don't off the top of my head know about that might speak to that. Um, but again, if you're being stalked, I think that would be a law enforcement issue before it would be a civil issue.
Okay. Then
Well,
in
actually, let me rephrase that. Because now I think about it, there actually is grounds for early termination when there is stalking. Let me find the.
yeah,
So I've been
early
reviewed,
termination.
and yeah, so
Yeah.
I've reviewed 92.061, sorry, 161 in a while. So I can't speak to that in any real depth today, but that might be something to look at if you are, like I said, dealing with a stalking issue or, feeling unsafe. And again, I would recommend contacting an attorney to assist you with this.
Okay. And I can't recall if you went through it in the presentation. At what point can a landlord enter the property just without your permission?
Usually that's spelled out in the lease agreement itself. So a lot of lease agreements will provide that there needs to be advance notice, or they may provide that they're allowed, entry at reasonable times in a reasonable manner. Um, and so I would, if there's a question about that, I would look to the lease first.
Uh, okay, and I hope I'm reading this one accurately too. Just want to make sure. But just to kind of sum it up, um, hotel guests and managements of hotel, does the same law apply for, I guess, someone that doesn't want to leave a hotel or short-term rental, or, you know, are the laws pretty much the same as it relates to that kind of stuff?
Um, they are not, but there are situations where someone is there long enough, it can become a forcible detainer issue. Um, I haven't, I can't claim to have dealt with any hotel evictions that hadn't been forcible detainers in a while. So I couldn't tell you the specifics of the hotel occupancy laws off the top of my head. That's another one where it's specific enough you may want to seek legal assistance to advise you on what your rights might be.
Okay. So realistically, because again, I know people tend to get confused on notice to vacate versus the actual eviction. People tend to think when they get that notice that that means that they only have 3 days to actually leave the premises, and that's not the actual eviction
Yeah.
itself. From the time someone actually receives the notice to vacate and the time they are actually evicted, officially evicted, where they are required to move, what kind of timeline, assuming that you don't pay the rent, assuming that you don't actually show up for court, what's the time frame for someone actually being evicted?
So the way this works is that you get your notice to vacate. It says 3 days, or it says, whatever it says. That's the first step to the landlord getting their possession of the property back. It is not a lawsuit yet, but it's likely to become one in the very near future. Oftentimes, 3 days is not enough time for someone to leave most of the time. If it is, it may be worth considering, leaving prior to the filing of the eviction. That way you keep your record totally clean. But it's going to be, fact specific, and it's going to largely depend on what you can and can't do, or what you're willing to fight and bear. Once the expiration date happens for the notice to vacate, the landlord files their eviction. Let's just say that it is on the fourth day. They give you a notice to vacate on a Monday, and then they file on the Thursday. The court has to accept the filing, set it for hearing, send somebody out to serve the tenant. On practical matters, that's normally about 2 weeks between, when the petition is filed and when somebody has a court date. It's not a whole lot of time. Once you get to court, the court normally issues a judgment the same day that the court, they don't sit on a judgment like that. You go to court, and that day either there's a dismissal or judgment in favor of the landlord or the plaintiff. Landlord or defendant. If it's in favor of the landlord, the tenant has 5 days to file their appeal. If they do, they get an additional 5 days to pay that 1 month of rent to the court registry. If they don't, the landlord is entitled to an immediate writ of possession. So, in practical terms, if you don't appeal from the date of the filing to the date of judgment, it's about 21 days on average, I think. And then you add 5 days to that for the appeal. So about 20, you're talking about, no appeal, you're talking about probably about a month. I don't know if all that specific makes a whole lot of sense, but you're talking about, you get the notice to vacate, it's entirely possible that the landlord can be asking for a possession within a month.
Okay.
Which
So
is
and then that includes the time the writ of possession is filed, and then the sheriff or the constable would then come and serve you to
this is
remove you.
where this is where things got a lot more complicated, because obviously, once the writ itself is issued and there's a constable on your way, how long it takes the constable to actually serve and execute the writ depends on the availability of constables to actually serve. And that can differ from precinct to precinct. There are some precincts that have a lot fewer residents and a lot fewer renters, and so you'd expect that those writs of possession would be executed earlier. There are some where there are a lot more residents, and so you'd expect those writs to be executed later. I don't know that I want to put an average timeline on it because
Right.
normally speaking, you know, we're not monitoring those cases at that point because there's not a whole lot we can do for somebody at that point.
Okay.
Um, the the key thing to note about if you're facing a writ of possession is that the constable is going to post the notice on your door 24 hours before they can actually execute the the writ. And so you'll get an advance 24-hour notice about when that final date is.
So I'm just trying to give tenants, like a time frame. Though if
Yeah.
they, once they, so upwards of 21 to 30 days, somewhere within that time frame for a
Without without with so without the appeal
without the
obviously
appeal,
adds potentially another month. Of course, you need to make the payments to the court registry in order to sort of have, those
those grounds to stand on.
yeah, those extra
Yeah.
days. And there are reasons to appeal 4 times you can afford the payment. There are reasons to appeal even if you can't afford that payment, you need to leave imminently. A lot of what we do, when we're advising people is talk about what the timeline looks like and, find out what their needs are and figure out, you know, what this actually looks like for each specific person. And maybe that should be what I emphasize here is that, the initial timeline between when something is filed, when the JP is going to hear the case, what that initial appeal timeline looks like, that's pretty much set in stone. Beyond that, there can be quite a bit of variability for different people in terms of what they're looking at. And
Okay.
so, like I said, that initial timeline, is preset in stone. After that, a lot of it depends on what you can afford to do and sort of what your needs might be.
Okay.
And
Ju-
it's
Just so folks know, when they receive that notice to vacate, that's not the actual
yeah,
eviction lawsuit, that you still have time to seek some kind of assistance, to
yeah,
seek some kind of some way to remedy the situation. That does not mean you have 3 days to pack up and move and find some new place to stay. So I just want to
yeah,
make sure that at least that part is out there for folks, because people start
yeah,
to really get in a panic. Oh, I'm
yeah,
late on my rent. I only got 3 days to move and find a new place to stay, and that's not the
yeah,
case. The other thing here that I wanted to clarify, and I don't know if this is going to put us back to a question that she had previously had. So if you receive the notice to vacate and you decide, you know what, I'm just not going to fight it. I'm going to go ahead and move. I want to pay the rent that I owe for this month or whatever, and I'm just going to leave. So if they decide to leave, then the landlord then at that point can't file, well, even if they don't pay the rent, they can't file the lawsuit for eviction because you've left the premises, correct? But
yeah.
you can
If you leave before the expiration of a notice, they are not allowed to file an eviction.
an eviction, but they can still
Now,
sue for whatever unpaid monies. Okay,
yeah,
so get to that
we
part.
we don't normally see small claims lawsuits for rent simply because Texas was founded in part as sort of a haven for debtors, and so we have good debt collection laws. And so it generally doesn't make financial sense for somebody to file a small claims lawsuit over rent. We do normally see that these are amounts that are reported to a credit reporting agency. Sometimes they're sold off to a third party debt collector. It really just depends. But circle back for a second. If you are leaving the property, another sort of best practice is document exactly when you are out and when you notify the landlord. There have been cases where someone moves out and the landlord files an eviction against them anyway for whatever reason. And obviously, those are not good evictions because you know part of the elements of eviction statute is that you have to willfully hold over after you've gotten your notice. And if you've left, you haven't willfully held over. If you're someone who is in a position where there was an eviction filed against you and you left and they got judgment anyway, there are certain things you can plead to the court to try and get the judgment vacated against you. And that it doesn't fix everything, but certainly helps not to have a judgment on your record.
Okay. Okay. I'm not sure how you can actually answer this question, and I don't want to really get into too deep into the woods as it relates to trust. Can I transfer my lease into my trust?
I I'm not sure I understand. I mean, there are two ways to read that question. One is a landlord basically assigning rental property to a trust, and that I believe would be allowed. The other is a tenant like signing their lease agreement. I don't know. I don't know in what
Whatever,
context that would
whichever
make
attorney,
sense.
I'd say whatever attorney created the trust, you probably should ask that real estate attorney as it relates to that trust. Um,
I mean,
because
generally
I don't want
speaking,
to get into to bogged into
yeah.
because trust are real specific to individuals, and so that's there's no blanket answer when it comes to a trust. It depends on your own situation. But as far as transferring a contract, once a contract, from my understanding, as once it's been signed, it's the person that signed it. You can't then reassign your contract to somebody else.
Well, just to sort of simplify this further to the sort of landlord tenant, you know, a lease agreement basically allows a person or a group of people to occupy, possess, and use a piece of property. Um, a trust isn't a person, it's sort of a relationship and a method of holding property for the benefit of a third party. And so, I wonder if there's a sort of category error here. Even like commercial leases you're talking about, they're renting to a corporation, which is considered a legal person, not to. So yeah, I don't know that I understand that question well enough to, answer it to any satisfaction. I don't want to. I feel like in order to get at the heart of it, I'd have to go deeper into the specifics. But yeah, I sorry, you got me stumped.
Yeah, that's probably a little bit outside of our scope here for this conversation. I'm going back to the social media pages just to see if I have questions here. I don't see anything on either of the sites. And I think I got to the questions that were emailed to me before too. And I don't see anything there. Okay, I think that's it.
Okay.
All right. Well, if there are no other questions, or if any of you, the participants here or watching those on social media, if you guys do have questions that you can think about next time, feel free to reach out to myself or to Benjamin, all of or to Lone Star Legal Aid, and we can make sure that your question gets addressed or that you um, have the resources that you need to apply for the services of Lone Star Legal Aid. All of that will be included on the email that I send out to you all. You also have the option to come back. Well, my recommendation would be to come back within the next month or two, because as Benjamin stated in the beginning, some things are kind of being put into place, and we don't know what kind of updates or changes are going to be coming in the near future. So we do these presentations because of that reason exactly. We don't know when laws are going to change, when processes are going to change, and things of that nature. So we want to make sure that those experts in those fields are bringing you the most up-to-date information as possible, so that you're not kind of out there hearing secondhand information or hearing information off of, you know, social, TikTok, Twitter, or from the street committee, as I like to call them, that, that everybody kind of knows something. They've been watching Law and Order for a while, and, or Judge Judy, and then they think that they know the law and then can kind of start putting information out there. So laws are very specific as it relates to the state of Texas. A lot of times, a lot of that information that's kind of out there is not relative to Texas, or it's not the same. It does not apply. So just keep that in mind too when you're out there kind of doing your own internet research, um, that you're looking at how things apply to Texas law. But then again, also just come back to one of the presentations to get, again, the most up-to-date and accurate information that you can. So we hope that you all found this information to be very beneficial. Hope that you all receive the information and the resources that you all need so that you can feel a little bit more empowered, know about what your rights are and what your options are and what's available to you. So we ask that you pay it forward. And if there's anyone else that you know may find this information to be beneficial, that you share it. Again, the link of the recording, as well as our social media channels where the information is shared, will be made available to you guys so that you guys can go back and watch it too. So, with that being said, thank y'all very much for joining us this afternoon. We'll give you the remainder of your time back. You all stay safe. Take care of yourselves. Benjamin, thank you very much. We appreciate you taking the time out this afternoon as well to present this information on behalf of Lone Star Legal Aid. And on behalf of the Month of Service Collaborative, you all have a wonderful remainder of your afternoon. We'll see y'all next time. Thank you.
Thank you, guys.